This next session is on modular fabrication, modular construction. This is something this is my first time presenting this PowerPoint. This has been something that I've been seeing a lot in the last 5 years, and I thought this would be hopefully a good topic. Sort of like when I boil crawfish, I always throw in something a little bit different, unexpected. This is sort of like the unexpected artichoke or something you get in a crawfish boil. Hopefully you like it. You might not, but hopefully you will. So we're going to do just a brief overview of what modular construction is, definitions, pros and cons, challenges, and other contract forms and clauses. So from 1971 to 2010, there was really little to no use of modular construction. We've seen in 2010 a really big uptick in it because I think it's mostly been driven by the technological advances that we have with computers and obviously the ability to work remotely. I'm just putting my little timer on, and others. And so we have seen the market share really has doubled significantly over the last few years. And they're expecting and forecasting by 2029, the market for modular construction to be upwards of $140 billion per year. And it's used across every market. This presentation is going to be focused on industrial fabrication, given where we are and the clients here today. This is not going to be about necessarily the prefab homes and houses that you've seen, although these principles still apply there. So this is going to be more of the industrial fabrication. So 1971, Disney was one of the first adopters of modular construction. I'm sure all of you have been to Disney one way or the other. So the Polynesian and the contemporary was supposed to be, well, it was modular fabrication, but the neat thing about it was that the idea was they were going to have the living modules just slid into the steel framework. And then when it was time to renovate those, they would just pop them out and put the new one in that was being fabricated off-site. It settled over time, apparently more than they expected, and the modules that are in there now are stuck in there for good. So well-laid plans, right? But the idea, it started back in the 70s, and again, for whatever reason, it just sort of didn't take off. So today's world, we've got real industrial fabrication. This is what we're talking about off-site. And these are some photos from a client that we have currently. And as I said, in the last 5 years, the reason why I wanted to put this PowerPoint together was because I've gotten calls from owners who are doing multi-billion-dollar projects all across the US, especially here in Texas and Louisiana, and they want to do modular fabrication because they're now able to source equipment and engineering, process equipment, process engineering, off-site from around the world, and they think that's better for them, and so they're asking us for form contracts. And I'll kind of cut to the end a little bit, but the AIA has no form contract. The consensus docs just came out with a couple of them, and they're very basic, rudimentary. So, and essentially you have to do a bespoke contract from the get-go. So prefabrication, let's just talk about what it is. It's technically anything that's done off-site construction. And the Off-Site Construction Council of the National Institute of Building Sciences, if you didn't know they existed, they do. They define it as anything that's done off-site that's fabricated other than at the final location where the facility will be built. So that's what we're talking about. You're doing most of the construction off-site and then shipping it to be installed there on the actual balance of the project site. These are some photos from a client that we work with and represent. These are some of the modules for the LNG processing facility somewhere in the Gulf South area. And these units, each one of these are the different modules. They make up the train. You've probably heard that phrase, train. These are the individual modules. This is, again, for an LNG facility. So each one of these has their own separate goal, if you will. And the idea is to pre-treat the LNG. They're all LNG. So one module may take out the mercury, one may dehydrate the LNG, another one may take out some other chemical. But that's the point of it. And what they're finding is it's easier to build these off-site and then ship them to the local area to be put into place. I put this picture up here because I thought it was fairly interesting, because I had asked the question, well, how do you get these modules up to, and this is in Mexico, how do you get them up to the project site? And they showed me this picture. It's fairly easy, just throw them on a barge. My dad's a naval architect, and I think he would appreciate that photograph. I did too. It's remarkable. Could you imagine seeing this being shipped upriver or across the Gulf of Mexico? They do it, and there you have it. And we'll talk about some of the issues that relate to that too. And before I go any further, I want you to just, if you have any questions or comments, just please raise your hand, whatever, shout them out. I'll be happy to ask or answer them too as we go. So here's some different types of modular construction. You have the single trade prefabrication, a pipe spool, for example, right? We have people in the audience who do that. Then you have a more prefabricated multi-trade rack. So you have a rack with different pipe spools in it. And then you work your way up to volumetric sub-assemblies. And you have a pod that could be a restroom pod that can be just slid into the location. And then you have the more heavier duty ones, the modular utility plant. Like that's the pictures we just saw, the LNG modules. That's it. So it sort of covers and spans the gamut as to what it can be used for or can't be used for. So why do people use modular construction, right? I think it's fairly obvious if you think about it conceptually at least. The idea is you can, and this is the key point right here, you get the benefit of building construction off-site while you're still doing your site prep. So while you have your civil people out there doing the cleaning and grubbing and whatever they're going to do, the grading and grubbing, you can have your off-site manufacturers building the modules at the same time. So theoretically, you should be able to cut some time, right? You also have greater quality control because instead of building things at site with all the other trades running around, they're now off to the side, usually in a nice covered environment with all their equipment set, and it's an assembly line process and you can control quality. Material management's the same, and theoretically, I don't think I have it up here, yeah, you do, safe worker environment. Again, you have less trades crawling all over each other, trying to get the work done because it's off-site. So what are some of the challenges? One, and some of these are axiomatic, you probably already can conceptualize this, but you're working and engaging with new partners across the spectrum. You've got to integrate the off-site components into the balance of the project. Who's going to do that? Is it going to be the person who fabricated the modules off-site? Is it going to be someone else? How is that relationship going to work? Shipping issues, obviously, for those of you who deal with logistics, and I know a couple of people in here do, the logistics and the risk transfer, it's fairly significant in this situation, as you can see from that picture I showed earlier of them shipping that module via the barge. Ensuring the quality and schedule of off-site work. They're off-site, so how are you, if you're the owner who's engaged, especially manufacturer in, say, Mexico or wherever, how are you going to ensure that the quality is done? That's another challenge. You're not there at the site. You have to have a new team inspecting the work as it's being performed. Again, it just requires extensive coordination. Obviously, every project requires coordination, but I think here it's at a zenith. It's critical, given the work that's being done in multiple locations. So these are some of the legal challenges that we are seeing. And then obviously the project team needs to be aligned and committed. I think that's, again, for every project, but I thought it'd be important to underscore that point here as well. So now, with that as backdrop, we now have talked about what modular fabrication is, how it's used, and where we see it going in the future. What are the legal implications of modular fabrication, right? So Texas has already been sort of at the forefront of this. Congratulations to Texans. I think because of all the industrial construction work being performed here, they've already addressed it in their mandatory building codes, and it says that components, and you'll see components they use that interchangeably with modules, they being obviously the Texas Department of Licensing, as well as that other organization I mentioned earlier. They use components and modules interchangeably. Components must be completed and inspected in the plant by a Texas-approved third-party inspector. So, and you have to meet all these building codes. So Texas is already starting to think this through and have already started to talk about, or at least address, the issues where I think other jurisdictions are way behind. That's important. And to think about it as well, another legal implication are liens. Is a specialty manufacturer allowed to lien a project if they're not paid? They're not a subcontractor, they're not a vendor, they're not a contractor. Do they have the right? So it depends. State laws vary, but it depends on your position. And a manufacturer may not have the right to file a lien, whereas a subcontractor would. Once again, though, luckily for us, Texas is ahead of the curve. Texas's lien statute was updated just recently, and as you can see here, they've already addressed the idea to say, look, we know there's a lot of modular fabrication being done. We know a lot of specialty fabricators are out there. For all intents and purposes, we want to treat them much like we would any other contractor in the normal stream or traditional stream of building. So even if the material has not been delivered or incorporated into the construction or repair, you still have the right to file a lien. Another interesting point here is in 2022, Texas eliminated the notice requirement, which I thought was somewhat draconian, that you had 15 days to provide this notice. 2022, as you may know, that no longer exists, that notice requirement exists. But as you heard from Brad and William in the presentation before, you should probably just do notice anyway, right? But here, it's not necessarily required for you as a specialty manufacturer to have your rights to a lien. Now this is, to me, the biggest issue that I've dealt with. And I've drafted probably over 20 different modular contracts across several different projects in the last 5 years. And I've litigated some from soup to nuts too, actually arbitrated. But the point is, this was something that came to my attention I'll be honest, as a construction attorney. I deal mostly in common law, right? It's not that often you see a UCC issue. They pop up, but I was sort of not surprised, but just it took me a little bit unaware, like, oh, okay, so what is it? What is governing this contract? Is it the UCC or is it common law? And for those of you who are attorneys, do y'all even remember what UCC is? I had to go back and dust off some law books. But the point here is it combines both goods and services, right? So you have someone, whether it be in Mexico or wherever, doing off-site construction that you're going to now bring to your balance of site. They're providing you a good. Ultimately, they're providing you a module. That is a good under the law, right? But there's tons of services required to get it there. So what is governing your agreement if you're the owner and you have an agreement with the fabricator, or if you're an EPC contractor who's subbing some of this out to a fabricator? Is it governed by the UCC or is it governed by common law? And I'm going to show you the stark differences between the two and why it's important for you to understand that. Are they a subcontractor or are they a manufacturer? And as we talked about earlier, that can have an impact on your ability to file a lien, or if you're the EPC, your ability to stave off a lien from your contractor, your specialty fabricator. Again, Texas has already addressed this and said, sorry, they have the right to file a lien even if the equipment or goods are not incorporated into the balance of the project. So is the contract for services or goods? That's the fundamental question. And as a result of the hybrid process, the traditional form of contracts just don't make sense. And again, you've got a situation where an owner comes to you, or if you're the contractor and you want these modules, you want them fabricated, you want them shipped up. Again, are you buying a good or are you buying a service? And you will see why it's important. Now, for those lawyers in the room, when you were taught in the UCC, when you took the UCC, like we all did, it's a balance of factors. Is it predominantly more goods or is it predominantly more for services? But if it's a hybrid situation like this, I think it's a good argument you can make on both ends. So, what are the differences? So you have contract formation, and everyone's heard of the Battle of Forms probably, right? We're going to get into that in a little bit. But there's other issues that pop up with the formation of the contract. And so we're going to go through the formation, and then we're going to go through the acceptance difference, the acceptance of the modules. Those are going to be the two big points of distinction I want to compare in today's discussion, at least for this particular issue. So this may blow your mind, it may not. It sort of took me by surprise that the UCC, which is different than the common law, they're actively seeking to find and offer an acceptance. So if you are purchasing a module, be aware that if you have terms that you've given to your fabricator and they have terms that they've given back to you either in a proposal or a PO and they don't match up, be aware an arbitrator or a judge will later say, you have an agreement and we're going to tell you what that agreement is. And I'm going to walk you through that in a second. But the UCC, they're actively trying to find an agreement. That's the key point. Even if you don't think you've got one. For example, contract forms, or you have a contract in any manner sufficient to show agreement. Even in the moment at the time, there are certain issues that are undecided. We haven't discussed price. Price is a pretty big deal, right? In the common law, that's a material term. If you don't have a price set, then you don't have a contract potentially. The UCC may say, no, you still have an agreement, and we're going to tell you what that price is. That's pretty crazy. Schedule as well. That's a material term. By God, how can you have an agreement, a meeting of the minds? We've all heard the meeting of the minds. UCC, as long as there is a manner sufficient to show agreement, even if there are undetermined issues, we'll take care of that later. We are trying to find a contract. We're trying to get you into this agreement. Multiple terms can be left open, and as long as the parties appear to have intended to make a contract, the arbitrator and the judge will find that you have a contract. So be on the lookout for that. Acceptance under the UCC is in any manner and by any medium reasonable under the circumstances, right? So think about how loosey-goosey this is. Lawyers will always use the word reasonable. It's a nice way to sort of hide behind an answer we don't want to give you, right? Here you have, I mean, look, it's just peppered with reasonableness, intent. There's no bright line test. But what the thing you have to always keep in mind is that the courts and the boards are actively trying to find an agreement, and you will have an agreement. You find yourself in an agreement with a specialty fabricator before you even knew it. So the UCC default, additional terms proposed by responding party will become part of the contract. Think about that. I issue a proposal to do the work as a fabricator, or you get a PO. Okay, great, here you go. Here's a PO. Go do what you said you were going to do. But you have to accept my terms. And then the fabricator is saying, no, you have to accept my terms. Guess what? Both of those are in the contract under the UCC. Think about that. That's kind of blows your mind, right? The offer, it's in there unless the offer expressly limits the acceptance to the terms of the offer, right? And this is what you see all the time. The fabricator says, here are my terms, and you have to accept our terms as is. You think you got it. You think you're good. Your terms are going to govern. You get the PO, right, from the contractor, or you, the contractor, issue the PO and you say, my terms govern. You have to accept them. There's going to be an issue. I'm going to get to that in a second. The terms proposed in response will be part of the contract unless they materially alter the first person's offer of terms. I'll get into that in a little bit too. And you have to give notice of the objection within a reasonable time after you receive those additional terms. So think about it. Two parties come together, you have to use my terms, no, you have to use my terms. What happens, as long as you don't have, if you don't meet any of these terms or these issues, they both will become part of the contract. So what is materially alter? And we'll talk about that in a second. So if you propose terms different than the terms that were given to you, do they materially alter it? What that means is, does that change, that's the new term, change and produce hardship on the other party, or significantly shifts the risk, or is a surprise to the other party? So unless your new terms create hardship or significantly change the risk or surprise, you didn't really materially alter the terms of the contract. So guess what? Those terms will be put into the agreement, right? That's what we just saw. It didn't materially change anything. It didn't create hardship, it didn't surprise the other party, and it didn't significantly shift the risk. Well, again, all these are fluff terms that are going to be litigated later on unless you define these, because these are not bright line terms, and they leave this is open to subjective inquiry as to whether or not this created a hardship or not. A material change made in the acceptance would be stricken from the agreement if a contract did arose, and under the UCC it would. So yes, if you can prove or show that, no, the terms I gave the specialty fabricator, my terms were different and they were a material change, then those would be taken out of the agreement. Then we get into this battle of the forms. So battle of the forms for those who are not attorneys, you have a situation where, okay, the fabricator presented their terms, the contractor who's buying those services and goods, or they propose their own terms, some of them don't match, right? And then that's a battle of the forms. Well, which form govern? Whose terms are going to govern this agreement? Pretty important to understand that, right? But the final agreement terms must match both parties' forms. Okay, well, I thought you said, Chad, just a couple seconds ago, it didn't matter. You were going to have a contract either way. The answer is yes, you still have a contract, but what happens is, if you propose terms and the other party proposed different terms, those terms that don't match up and there's a dispute, those are knocked out. You still have a contract, but those terms that are different, say my terms, everything's great, your terms, everything's great, but we have a conflict on schedule. You saying I'm going to do my shop cycle time of 4 weeks, and the other guy says, no, I need it in 2 weeks. You've got a conflict in those terms, right? What happens under the UCC, though, that schedule is knocked out. The schedule that you proposed and that the other party proposed are knocked out on schedule. You still have a contract, and what happens is the UCC, thankfully under Article 2, comes in and they will propose a term for that schedule. You didn't negotiate that term. The UCC, in their great wisdom, will come in and tell you, let me tell you what that term is going to be. Likely it's going to be a reasonable time period, right? Because that's what lawyers do. They use the word reasonable. So you think about this, that's the big issue, right? You've got two parties coming together. You will be in a contract, even if your terms don't match. And I've had several conversations with clients who said, how can we have an agreement with their term when I specifically have my proposal saying that my proposal terms govern? Well, because the other side said that their proposal terms govern, or their PO terms govern. Well, that doesn't make any sense. I didn't agree to it. I said, I understand that, but it doesn't materially alter it, so therefore their terms come into play. So you've got to be thinking about these things when you're getting into it. And when we're talking about these modules, like these LNG modules I just showed you, we're talking about tens, if not hundreds of millions of dollars are at stake. And if you don't fully appreciate this issue, you could have some issues in the future. So that was the UCC, the common law. Let's think about that. This is going to be super easy for all you attorneys in here. Texas has a mirror image rule, which essentially says that they both have to have identical terms, otherwise there's no meeting of the minds, right? So if the fabricator says, here are my terms, and the EPC contractor said, well, here are my terms, you're not going to have a contract unless you both sit down and hammer out what are going to be those final terms. Additional terms are to be construed as proposals, and acceptance with different terms constitutes a counteroffer. So you have an offer and acceptance, right? That's common law. Here, if you have a change in the term that's proposed, you have made a counteroffer. You haven't reached that meeting of the minds yet. You don't have an agreement. You have no agreement until there are a complete mirror image of both terms from both parties match up. That's the common law. So you don't technically have a contract. Well, what if you continue to operate as if you think you do? Then we get into the whole fairness word, and you're now talking about unjust enrichment, and you're talking about equitable remedies. You're now off contract. You always want to be on your contract, obviously. So here's I say it's a hypothetical, but it comes from a case from Texas from 2021, and it's the ETC interstate case. I'm not sure if you've read this, but again, we practice all across the nation, and I'm seeing more development of the law here in Texas because I think there's just so much industry using modular fabrication here in Texas. So again, you have a price quote from the pipe fabricator, and it's sufficiently detailed. And that word sufficiently detailed means, according to this case, you've got to have more than just saying, I'll give you 10 spools of pipe and they'll be on this day. It's got to be a little bit more detailed than that. You've got that from the pipe fabricator, and it contains language that any terms that are different are hereby rejected. Pretty good, right? You think you're solid as a pipe fabricator. Purchase orders received in response, many different terms, and they have their own language that says acceptance of this purchase order is limited to the acceptance of the express terms contained in herein. So this is exactly what happened. We talked about this earlier. This is exactly what happened in the interstate case. You have two parties coming together, both saying my terms govern, and you can't accept it unless my terms govern. Is there a contract? At this point, hopefully you would say yes, under the UCC. Under the UCC, the answer is likely yes. All the terms from both parties are into the agreement, and if there is a dispute over one term or any terms that conflict, that term is knocked out, and then the UCC will replace that term with its own term, which again is usually reasonable. Yes, sir?
Are you saying that the fabricator did not sign the purchase order?
They signed the purchase order in this case, I believe.
And why wouldn't that govern them?
Because the UCC says because the especially fabricator is saying, pipe fabricator is saying, but my terms are here, and you giving me your proposal or your PO doesn't knock out my terms. My terms still exist. I know what you're saying, but you signed my agreement that said specifically my terms govern. Under the UCC, that may not be necessarily the case. I had the same aha moment about 5 years ago when I saw this. I'm like, that doesn't make any sense. And this case, it was heavily litigated, as you can probably see. That's why we're talking about it here. And that wasn't sufficient because the courts went to the UCC and said, by giving that purchase order in return, maybe that purchase order was your acceptance of their terms. And the fact that the other guy signed your purchase order that has this language, we're not sure what that is. But we do know this, that you have an agreement once you sent that purchase order where you showed an intent to be bound to this agreement. And then now we're talking about, so we have a contract, so now let's talk about the terms. And under the UCC, they say, okay, the terms that are inconsistent get knocked out and we will replace them. But that's the same concern that I can see you're kind of skeptical. That's the problem. And we're talking about a lot of money here on these modules. This is something you need to think about. Under the common law, likely not a contract because there's no mirror image. There's got to be the same terms. Now, to your point, maybe you do have a contract. This wasn't analyzed under the common law because it was considered a good, not a service. Pipe. So it's UCC. Again, the UCC governs goods and the common law governs services. So here it was a UCC agreement and the court said you have a contract and both terms come in and we're going to knock out the ones that are inconsistent. That's ultimately what that held. Now, the UCC is more than just a battle of the forms. And in fact, when we were litigating this case, me and my fellow partner, William, I don't see him in here now, about 4 years ago, the other side took this position and said, well, yeah, I understand the UCC is there, but the common law, really, that's what governs. The common law is That's what the American system is based on, right? The common law. And the answer was no wrong answer. In that ETC interstate case, that argument was also expressed, and the judge there was very clear and said, no, if it's a good, then the UCC will apply, and we will only look to the common law as principles to complement the UCC. Only if the UCC doesn't govern it already. If the UCC covers it, then we're going to defer to the UCC. I don't care what the common law says, the UCC governs. Again, we're talking about modules and things that are fabricated off-site. Ultimately, there's a lot of services, but ultimately you're buying a good, and is that good, is that now the UCC world? And the answer is probably so. And this case here in Texas says the same thing. So that's the formation issues. Again, the key takeaway there is just be cognizant of where you are in the process and what you're signing up to. And it's pretty tricky, to be quite frank with you. So now any questions before I move on? Yes? They consider that a movable?
They consider these large-scale modular builds removable, where they can find like a security interest.
I haven't gotten into that particular issue, but the answer I would say is likely not, because what you'll see, I'll see this in a second, these contracts people are using traditional form contracts, service common law contracts, and they're not really getting into what you're talking about, the secured interest and all those issues that come along with, now you're talking secured rights and secured creditors and UCC, secured transactions, right? Going back to law school for those of you guys. I took that class and yeah, right, let's be honest. There's no professors here from that, we can rag on it now. But no, that's the nuanced point, because now it's a good, arguably, and you've got a whole host, you got liens, you got secured interest, and then you're going to get into the acceptance, which I think this is even crazier, if you can believe that. But did I answer your question? The answer is I haven't seen anyone get that level of sophistication in their agreements with regard to that, but that's a good point, and I need to start bringing in my bankruptcy guys to look over the contract to give me a good clause to address that issue. No, not yet. So acceptance. Any other questions before we move on to the next topic of acceptance? Okay. I accept the silence as acquiescence. All right, acceptance. Important to set the risk up front. Parties define inspection and acceptance in their contract. So under the common law, look, common law is, like we all agree to, it's a mirror image. Either we come to the terms, we all agree to it and sign it. If you don't like it, tough, you signed it, we now have a contract, let's move on with our lives, right? And so you have a lot of control, a lot of ways to negotiate and put that into your contract. Final acceptance typically, and we're talking again in the industrial setting, you have mechanical completion, that's usually well-defined, and then when that's obtained, you get a certificate of mechanical completion, right? Easy peasy. Same thing if you have substantial completion requirements, you have to meet certain P specs, you're going to get a certificate of substantial completion. And until you get that certification, which is usually an appendix to the contract that shows the form that it needs to be in, until you get that, you haven't reached substantial completion. But they are defined up front, they're in the agreement, it's something that we're all used to seeing in these big EPC contracts, right? Or EP or E or EP or PPC or whatever it is contracts we want to call it today. Modular construction, just important here, sort of similar to the common law, is when you're talking about inspection or acceptance, it's important to grant access to the site so that people, the owners, whoever's purchasing those goods can be there to do it, to inspect it. So the UCC acceptance, again, because we're talking about goods and the UCC hasn't really been dealing with this kind of off-site construction that we're dealing with now. It's been usually, your typical goods, wherever that might be. Nothing to this level of sophistication, nothing that has mechanical completion requirements or substantial completion requirements. I mean, think about the level of sophistication that comes along with that. The UCC just, I don't think, isn't set up for that. The common law and the agreements that we do have, I think, are. So what is acceptance under the UCC? So again, now the UCC is, buying a bottle of water. That's governed, that's a good, you're buying, that's governed by the UCC. So we're trying to have this hybrid process and this highly complex, highly choreographed world of offsite fabrication, moving it to the site for installation. But under the UCC, which likely will govern a modular contract, acceptance occurs when there's been a reasonable inspection and after the buyer signifies that the goods are conforming and that they're going to take it. So again, it's important here under the acceptance point to think about this. This is, if it's not defined in your contract, then this is going to be what you're going to be living with as a UCC contract. Pretty crazy. Again, it's this amorphous, reasonable test that, okay, well, what is it? Did you accept it? Here's where we come into, I think, the crux of the issue. If the goods that if you're buying the modules and you go there and the pipe fabricator or whatever tenders it to you, and if the goods have defects in them, what is the buyer's obligation to take it? Or do they have an obligation to take it or not? And what if there is no commitment to correct it, then technically there's no obligation to fix it. Because you get a chance, when you get this water bottle, you get to inspect it, and you should know up front, look at it, I don't like it, this doesn't conform with my agreement, I don't want it, I reject it, right? If you don't do that, if you don't formally reject that good, that big module that we just saw being shipped up to the coast, if you don't reject it, you have just now accepted it. And I'll show you some examples of what that looks like. But if the buyer fails to make an effective rejection after he accepts or she accepts the goods, then you just now accepted it. And acceptance has a whole host of issues I'm going to get to in a second. And you can reject it, but only you can reject it if it's been reasonably rejected within a reasonable time period. And rejection is typically an act inconsistent with the seller's ownership. Okay, that's big. That's a mouthful. And we're going to go into the next slide. That's going to show us some examples of acts that are inconsistent with the seller's ownership. Say the buyer takes the modules and there's a punch list, right? And does that, taking them with a known punch list, if there's still some open items, is that acceptance? Under the UCC, it would be, unless you said, these are open punch list items, you need to complete them before I will accept them. Okay, well then I'm going to keep that module in my yard and do my punch list. No, but I need the module now because the plant needs it to connect. Okay, well then you want it, you can take it, but you're going to take it without this. And you can see how that is a sophisticated discussion. That isn't going to happen in most places, right? That's what gets people into problems. If the modules are connected and tested at the site, that is an act inconsistent with the seller's ownership rights. Changes to the modules, if you do any kind of performance test that is somewhat invasive, and I would argue the other side is going to say that they all are, that may be acceptance. If you're commissioning, you have to commission. That's an act inconsistent with the seller's rights. Therefore, you have accepted those modules. So, again, common law. Here's where I guess, let me just go all the way through here, because I think it's important to see it. So under the common law, acceptance means, why it's important, that means if you can withhold payment under the common law, right? Because you usually put that into your contract. Under the UCC, if that's not addressed, here's how the UCC is going to handle it. And this is what's really mind-blowing. If you accept those goods, do anything inconsistent with the seller's ownership, commission those modules. You've now accepted it. You have an obligation to pay for those modules 100%. You the buyer have to pay 100% of the modules unless you've rejected it, which as I said earlier, you probably haven't. And it has to be within a reasonable period of time. And this is what gets people into trouble is, well, no, but everyone knew that there were problems with it, and I have the right warranty, and I can withhold money. Well, if that's not in your contract and the use, or if there's a conflict in terms, and you can see how that could easily be the case, guess what? The UCC is going to gap fill, and it's going to be, no, you've accepted it, your rejection wasn't clear enough, and you're now calling me up asking me to help you get out of the situation, which you don't want to find yourself in. So that's the key point. And so under the UCC, defective modules may not be a legitimate defense to full payment. Now, this is a case in New York from 2009. I haven't found a case in Texas yet on this issue on point, although I litigated this in an arbitration and we came out good on this one, but it's not reported, obviously. But here's what it says. Even if the goods are defective, and if you know about it, if you as a buyer know that the goods are defective and don't get a commitment right then and there in writing from the supplier to fix or correct it on their own dime, you've accepted it, and that is a separate, you have to make full payment. And any kind of damages you might have, that's separate and apart from the indebtedness of the purchase price. In other words, tough, you go pay that fabricator 100% of the contract, and you now have to chase them for the balance if you didn't document it properly. Yes, sir.
What about common law rights of set off?
Common law rights of set off, if it's in your contract, it might be there. If someone says you can't have common right law of set off, it doesn't work. And set off may not apply because that's a common law principle as well. This is what makes the UCC such a gnarly little animal. And that now we're moving into the fabrication issue. We need to be very aware of it. So, upon acceptance, they become liable for the whole contract. That's Texas straight up. If buyer gives notice of defects and delivery of non-conforming goods, then they may be able to withhold some money. Neil, I think that goes to your point just now. But the key thing here in the Texas case, even when you have given notice that this module is defective, I'm only going to take this, but I'm going to hold certain money off, you have to only be able to, you can only withhold the actual damages. And in this case, they said, well, we think it's going to be $1 million to fix, whatever it was. And the court said, no, that was too much. You wrongfully withheld because under the UCC, you had an obligation to pay for the entire amount. And therefore, you can't use that set-off right that we see in the common law as often as we do. So now you've accepted it. So as a buyer, you've accepted it. Can you revoke it? Yes, you can revoke it under the UCC. You can revoke your acceptance, but it has to be timely, reasonable amount of time. There's that reasonable again. And it has to occur before there's a substantial change in the conditions of the modules. Again, there's tons of cases, I was going to say tons, a few cases, it's tons compared to the lack of case law. But there are cases out there that if you do any kind of test on those modules, guess what? That is a substantial change to the modules, and you can't revoke acceptance. You're stuck paying the full amount. Even if you find during commissioning that you may have come across a defect, tough. You have to pay them their full amount, and now you have to chase them because you didn't revoke acceptance prior to you performing a substantial change in those modules. Something to be aware of. So, key points, contract formation on the UCC. You may have agreed to terms you didn't even know you did. Be aware of that. Acceptance, anything inconsistent with the owner's rights. Once accepted, no more rejection of acceptance. You can only then revoke within a reasonable time, and you need to do it pretty quickly before anything substantial changes. And then payment under the UCC, once it's accepted under the UCC's terms of acceptance, you have to pay the full amount. Common law has right to withhold, and then the liquidated claim versus non-liquidated claim. Under the UCC, your claim as a pipe fabricator or the module fabricator is liquidated because they've accepted your goods. They may have an unliquidated claim because they now have alleged defects, what have you. That doesn't offset it, potentially. So, last topic in this section, and I think I've got 20 minutes left. I got that 10-minute sign just a couple of seconds ago, but there you go. So the last part is the foreign modular contract agreements. This is, again, why I've been called a few times in the last few years. on this issue is because are there any form agreements? The AIA, no. There are no form agreements in the AIA. The consensus docs, we're going to get into that in a second. They have put forth, I think, 753 and 253 are the two terms or two different form agreements. I've looked at them, and I'm going to show you what they've added. I don't think it's all that impressive. So here is the consensus doc 753. And this is the standard agreement between a contractor and a prefabricator. So what they've done is they've tried to now get, Texas has already handled this by way of the lien issue. I think the consensus docs wanted to get ahead of this as well. And they said, okay, we're going to now try to make sure that the fabricator isn't a manufacturer, but they are a true subcontractor. So they use these terms fabrication site versus work site. And the scope of work under the 753 consensus doc, this is literally the only thing they changed was they added the word component. And look, I like the consensus docs. I know those guys. I'm not poo-pooing on them, but my point is, don't use the consensus docs without thinking you having to do a significant amount of editing to those documents. Because they've added components and they think, look, that solves a lot of the issues. So now the subcontractor work includes labor, material, equipment, and components. Okay, that's good. That's a good start. What does components mean? Component means that the prefabricated elements constructed at the fabrication site prior to the installation of the work site. And then it's also defined in the subcontract work intent of the builder to be considered as a subcontractor. And then this same document has test inspections. Prefabricators shall provide access to all areas. That's an important point. Kudos to them on this because all that fabrication and construction is being done off-site. You've got, at least they've thought about that in advance and given the contractor the right to come in and inspect, thoroughly and inspect. And usually you see this accompanied with an NDA as well, or some sort of indemnity agreement as well. But that's something they have added. That's a plus. We'll take it. I'll take my victories where I can get them. They've addressed the risk of loss. The risk of loss being after it's transported and delivered and tendered to the actual contract site, the work site. I'm not a big fan of that, but it's tomato, tomato. If you want to shift risk and have it, FOB or at the fabricator site or at the site, whatever. But just so you know, this is the standard language, and this is how they have that risk being shifted. It's shifts the risk of shipment and logistics are on the fabricator until it's delivered to the site. So they've also added this. This is pretty neat, right? This is what we've been talking about all morning, last couple of minutes. What's governing, common law or the UCC? They've put this into the consensus doc 753, and they give you the opportunity to decide up front. This is helpful, right? At least you know going in what you're dealing with, and you make a decision, everyone's aware of it, and if you check the common law box, then that's going to alleviate a lot of those problems that we talked about the Battle of the Forms, et cetera. Unless you like the Battle of the Forms, and if you like the UCC, I think the UCC can give you some clarity. And if you're the pipe fabricator, I would probably be pushing for the UCC. If I was the EPC contractor, I'd be pushing for the common law, right?
Chad, is it that easy to opt out of the UCC? I was going to ask you earlier. I mean, just pick, right?
I think so, yeah. And thankfully, I think we still appreciate the fact that you can contract for pretty much anything you want to, at least for right now. And so I think the answer is yes, Texas would enforce this provision. I think most jurisdictions would enforce this provision. Maybe not California or New York, but that's a joke for my New York and California friends. But not a good one apparently. But the point is you can opt out of it, but just know what you're opting into or opting away from when you sign or you check that box. So look, again, I'm giving credit where credit's due, and I think that's an important issue, but it just goes to underscore everything I've been saying. I'm not the only one who's seeing this issue. Others are seeing this in the industry, and this conflict between Common and the UCC is pretty crazy, especially for construction attorneys who I think are brought up and steeped more so in the common law than in the UCC. Warranties provisions, always something to be on the lookout for. So your typical good, right? It's usually just you're only getting a warranty for what the good is there for, and it's for the materials. Common law, you would get normally workmanship here. They've thrown in workmanship as well. So, you know, these modules, as you saw, there's a lot of material and goods coming or being put into these modules. There's an awful lot of services required as well. So with this provision, the standard 753 doc says is that the module fabricator is standing up not only for the good, but also the workmanship. So I think this favors the EPC contractor or the owner buying the good. So again, depending on whose ox is being gored and whose side you're representing, think this through. Do you want this to be in your 753 or not? There'll be some modifications. Warranties are knocked out if there are modifications performed by others. I'm not sure if that's all that clear. So is commissioning considered a modification? Because the modules are shipped up, they're connected. Someone's got to do one, the connection, and then two, who's going to do the mechanical completion or the substantial completion, really? And is the module mechanically complete once it's delivered, or is it mechanically complete once it's connected to all the other modules in the train? That's a question. I don't know the answer, but that's something you need to think through and put that into your contract, right? Because I've seen situations where the EPC contractor is saying, well, no. You, the module fabricator, was supposed to reach mechanical completion for this LNG module, and mechanical completion means it's ready to go to be performed, tested through performance tests and commissioned. And the other response is, well, how can that be? You see all the ship loose material sitting out there. You know we didn't complete it, because typically when these modules are shipped, there's loose materials and goods that are only connected at the site by the EPC contractor. That's common. That happens on almost every one of these issues. So how can it be mechanically complete if there's still a good amount of work that needs to be done to even reach that point? Not to mention you got to connect it. So how can it be mechanically complete, and do you connect it? And who's doing that connection? It's the EPC contractor. Now they've done some work to connect them. Does my warranty go away because you've modified it? That modification, that arguably is a modification. Again, I don't know the answers to this, but I don't know if this form agreement is better than the AIAs. They don't have one. But it is, again, this burgeoning field that we're seeing, more use of these things. You just gotta be aware of what you're doing. Make sure you don't give away a warranty or cause conflicts that you're now calling up people like us to help you out through it. So again, I think it expands the warranty from more than just your typical product warranty to one of workmanship, but I do question that phrase I have highlighted there. So we're about just 4 or 5 slides away, so just give you a little heads up, we're coming to the end. I appreciate your attention. Modular form agreement, here's now consensus doc 253. So the last one we just looked at was 753 between essentially an EPC and the modular person. Now we have an owner directly with the modular fabricator. And again, going back to the start of this discussion, we're seeing this more and more now because we have more sophisticated owners building these multi-billion-dollar facilities to process LNG or what have you. And they're like, well, hell, I just go straight to the fabricator in wherever, Malaysia or where have you. And I can do this myself. Thank you. I can do this myself. I don't need to bring in a CM or an APC. I can just hey, they're building this module offsite, just ship it here, hire somebody to connect them, we're good to go. And so this form agreement 253 covers that. And I put a big asterisk on this one. Again, this is like 101, not PhD level contracts, but they at least tried to do something which is better than the AIA. Again, not taking sides either way, but just FYI, there needs to be some additional work on this. Provides for the option for the design delegation. So, okay, now you're representing or you're working for the fabricator. Are you now taking on design delegation if you have a direct contract? There's a whole host of issues that come up, but this agreement at least allows for certain design fabrication or the delegation of the fabricator. I don't think there's really anything else earth-shattering there. Transportation here, they have the fabricator also dealing with that and taking the risk and the risk of loss during the prefabrication site. Fabricator bears the risk. Post-delivery, the contractor does. And then for post-delivery, where the prefabricator is the installer, they usually bear the risk, at least in the Form 253 that the consensus docs has. So with all that, we come to the last, or second to last slide, and this is the wrap-up, right? So better defined scope of work, not just adding components. I think that's something you need to be aware of. Because again, the consensus docs is a good start. My New Orleans accent comes out every once in a while. It's a good start, but you need to add more to it. Define the party responsible for the integration at the project site. You got to think about, okay, so now they're commissioning or doing the performance tests. They're responsible for the reaching substantial completion, but how does that impact the warranty that I'm getting from my fabricator? And is that commissioning work now going to impact that warranty? And you need to be thinking about that, because under the UCC, it very well could, and that could be a significant issue to deal with. Who's got the design responsibilities? That's always something to be aware of, obviously. Depends on what agreement you're dealing with. Mechanical completion, substantial completion. If so, who's doing the performance tests? And again, are those performance tests going to impact the warranty? So you take this agreement and you bespoke it and you say, any commissioning work will not be considered to vitiate or void the warranty. That's one way of handling it up front. Should it be at the yard? I would say yes if I'm the fabricator. I would say no if I'm the EPC contractor. Cleaning, right? Cleaning, what's the big deal here? Well, in the industrial facility, as you guys all know, the context, cleaning is critical. And so how you define what cleaning is being done or whose responsibility it is can have another impact too, because the pipe fabricator, or the modular fabricator is going to say, I don't have any cleaning. All I'm doing is hydroing and drying it out. After that, it's all on you. I'll put some nitrogen in, preserve it, and ship it up to wherever you want me to ship it to. But I'm not cleaning because it doesn't make sense, right? Why do heavy mechanical or chemical cleaning at the yard to then ship it up site in a pristine condition where you have the EPC contractor come in? They're going to hook it all up. There's going to be weld splatter. There's going to be all that good stuff. And guess what? They're probably going to have to do that mechanical and heavy cleaning again too. So think about it up front, but also be aware, is that cleaning going to impact my warranty? Yada, yada, yada. So there's a lot of little nuances going into it. And then finally, the warranty issue as well. And then delay damages. That's another issue you have to deal with, obviously, with every contract, but I think it's important here, and there's some nuances associated with that. So with that, I think I'm on time. That's a picture of me. Yes?
I want to make sure I understood one point, and assuming I didn't, watch your call time, I did. I'm going to hear correctly in Modular Forum's discussion and after training levels and where I'll ask a question. If the suppliers, T's and C's say our T's and C's control, but a purchaser then issues a PO, says our T's and C's control, even if the supplier signs the purchaser's T's and C's, you're still out of the form, still not got rules, still gap filling.
I think, yes. I think that arguably that's the problem that we saw in ETC too.
Can you not just address that more specifically in PO, something that says supplier expressly agrees or supplier revokes or disclaims all the crap they sent us before?
Yes. I think it would. I think it would help, certainly. But the concern that I have is you've got these judges and arbitrators who are focused on UCC, and they say, well, look, no, we sort of like the salami method. We take it step by step. Is there a contract? Did you show any intent to enter into an agreement? And that purchase order that was sent back in response to the proposal, that may be enough to show that we have a contract, right? Irrespective of whether the manufacturer signed that purchase order with those terms in or not, you have a contract. Okay, we got a contract. We have a meeting of the minds under the common law. Then the next step in the analysis is, well, what is the contract? And I think the battle of forms would come into play. And would your point be evidence? Absolutely, to say this is this way. Or would the court say, sorry, under the UCC, we're talking just, this is like tried and true. We've been doing this since Moby Dick was a minnow. This is not new under the sun. These are just goods, right? Guess what? Your terms are in conflict with their terms. I don't care if they sign your PO or not. I'm going to knock those out, and the UCC is going to gap fill it, and there's your contract. So I hear what you're saying, and that's the issue that we had to litigate. Now, we were on the other side. We wanted the UCC to come in, and so we did win that. So maybe that's one point of data point for you. That's the concern. Yeah, that's the concern that I had when I saw this and we're going through this analysis. And I think that's something we all should be aware of and thinking through. Any other comments? Yes, sir.
Have you ever seen a situation where a client is novated to the EPC contractor on these consensus documents?
What do you mean, novated?
Well, like, they take a 253,
Mm-hmm.
Which is between the owner and the fabricator, and say, all right, now, Mr. Prime Contractor, you own that contract.
Yeah, I've seen that, yes. Yes, I have seen that, not necessarily with a 253. The 253 is sort of new, but to your bigger point, yes. Now, you're going to take that contract over for me. And
So that's going to force potentially a UCC discussion.
Yes. If it's for a good, if it's for a module that's built off-site, that's now being shipped up, that's the nuance of this whole issue. And I think people are just rotely going through the process. And fortunately, there haven't been that many disputes on it, and not many cases reported on it at least. But I think this is a point of friction that I think could get people into trouble. We can address it through the contracts up front, but just something to be aware of.
So
Yes.
to the previous question, when we were talking about specifically claiming the UCC coverage under the consensus doc, would including that in a original contract assist with that discussion, or do you think no? Like a specific disclaimer of the UCC applying in the event of a
Yes, so
discrepancy.
the UCC does not apply, is what you're saying.
Right, and so, and my question is like, so let's say we have general language in the purchase order which says, our law controls, or our requirements control the original agreement, and the original agreement expressly disclaims the UCC applying in the event of a discrepancy. Do you think that would hold?
I think it would.
So it's actually using the language like express
And disclaim UCC. I haven't seen, that's the issue. I don't get phone calls when things are going great, right? And so every time I've seen a dispute on this issue, it's been no one has done what you just said, expressly disclaimed it. So I haven't seen that, but I would think just basic contract formation, thank you, basic contract formation, that would govern it because you have the right of freedom of contract, at least for now, again. Yes, sir.
Yeah, so the disclaimer would be no UCC versus the typical disclaimer that you use, no implied warranties, that kind of thing.
Exactly.
No fitness for purpose, that sort of thing.
Exactly.
So you would add the words, expressly this waiving of rights under UCC or whatever.
Exactly, and in fact, I think this provision that they have in the, that they have in the consensus docs may be all you need, right? That may be sufficient, but you had to check the box that says common law. Or maybe the next sentence would be, and the parties hereby expressly disclaim or exclaim or do not include the UCC or any principles within UCC, and that this is a contract for services, not for goods. The more you put in there, the better. And I do think ultimately the initial threshold question is, what is the framework? What is the lens we're going to view this agreement under? Is it going to be through the UCC or through common law? I think the judge or the arbitrator would have to say, freedom of contract, you've disclaimed the UCC. Therefore, even though you're ultimately getting a good, I'm going to go with what you guys wanted. You wanted common law applied, I will apply common law. But then that could be in a bunch of trouble if there's not that mirror image rule, which I think, for the most part, you'll have.
But you would go with one step forward.
Yes.
Beyond the sole and exclusive remedies and all implied warranties are waived.
Exactly.
You
If that's what that's
actually mentioned
yes.
the UCC, which is the key.
Exactly.
Fair.
Precisely. Any other comments, questions, or derogatory statements before I turn over? Neil, no derogatory statements. Neil's my partner.
If you you are manufacturing or responsible for supplying the modules, never let anybody use the term plug and play in relation to the modules, because that will be prominently featured in the claim when it's not plug and play. And conversely, if you're the EPC contractor, you want to talk up plug and play as much as possible.
Yep. All right, very good. Thank you for your time and attention. Thank you.